Imagine if the most popular rifle in America, the AR-15, and also magazines were declared outside of the protections of the Second Amendment. That's not just a hypothetical, that is now up for consideration in the Supreme Court. And the question before the court is very simple. The question is, does the Second Amendment guarantee the right to possess AR-15s and magazines? So let's talk about what is happening in these critical cases and some things that have developed that may impact this case going forward. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. You can also turn on the notification icon and turn on all notifications because that helps to ensure that YouTube will actually send you these videos once I release them. Now, as I mentioned in the intro, in this video, we're going to be discussing a critical rifle and magazine ban challenge that have now gone to multiple Supreme Court conferences. Now, the primary case that I want to talk about is called Vermontes versus Cook County. And in that case, the petitioners are individual citizens along with organizations like Second Amendment Foundation. They are challenging Cook County's ordinance, which makes it a crime to sell, transfer, or even possess so-called assault weapons. Now, that term, as defined in the ordinance, includes about 100 different rifles by names, also includes things like AK-47 platforms, and then there is also a characteristics ban where if they have certain features like pistol grips, folding stocks, or muzzle brakes, they are also defined as so-called assault weapons. This case tries to leverage also the recent statements made by Justice Kavanaugh after the Snope rifle ban denial that happened last term. In that denial, Justice Kavanaugh stated that the time will come soon that they will need to take up a rifle ban and address this issue. He indicated that that could also happen maybe in a term or two. And the plaintiffs in this case now push this challenge as the proper vehicle and the proper case to fulfill that promise. And the Supreme Court has once again relisted review of this case and also the Duncan magazine ban challenge, so it's heading to another conference. This could mean a few things for the future of these challenges going forward, so we need to talk about what is happening in these challenges. Now, here's essentially how this rifle ban got into the Supreme Court. Back in 2021, the rifle ban lawsuit was filed in a federal district court in Chicago. The petitioners challenged the county's ban under the Second Amendment, and essentially in 2024, while this case was still pending, Illinois passed a statewide assault weapon ban, the PICA case, the PICA law, and that overlapped essentially with Cook County's current restrictions based on the ordinance. Around the same time, the Seventh Circuit ruled on and decided a different case called Bevis versus Naperville, upholding Illinois' law, and they claimed that AR-15s are too militaristic to be protected arms under the Second Amendment. They ruled that firearms that are useful in military service could be banned or that certain restrictions could be placed on those items. The district court was bound by what the Seventh Circuit said, so they upheld Cook County's rifle ban in this case. The district court issued a summary judgment in favor of Cook County, and then in 2025, right after the Snope petition was denied, which was a Maryland case dealing also with rifle bans and magazine bans, the Seventh Circuit affirmed what happened in this case from the lower court. Now in this case, the petitioners are asking for the Supreme Court to step in and resolve this conflict. They ask for the Supreme Court to declare once and for all whether Americans have a constitutional right to own AR-15s and similar semi-automatic rifles that states and counties are banning. The petition argues that the circuit courts are split and deeply confused on how to apply Heller and Bruin and the analysis that was outlined in those cases. Some courts are saying that AR-15s are arms, but can still be banned or restrictions could be placed on them. And other courts are claiming that these items are not arms at all and therefore they have no two-way protections. Petitioners say that the Supreme Court needs to clarify that all firearms, including these semi-automatic rifles, are arms under the Constitution. Cook County responded by arguing that the court should once again deny review to this rifle ban case. And then also in the other magazine ban case, you have California arguing that the Supreme Court should deny review to magazine restrictions. Cook County argues that this case does not warrant the court's attention for multiple reasons. First, they say that there is no circuit split on the issue of rifles being protected arms. Second, they claim that this case is a poor vehicle since the plaintiffs failed to follow basic court procedures, skipped discovery, and offered no admissible evidence to support their claims. So essentially, in other words, Cook County is claiming that the plaintiffs rushed the whole case and process here to get this to the Supreme Court as soon as possible, and they argue that some procedures were missed and therefore the Supreme Court should not review this case. Finally, Cook County contends also that the lower courts were even right on the merits of this issue. So in summary, they say that this case is procedurally defective, legally settled, and it's not the right vehicle or case for Supreme Court review of this whole assault weapon ban issue. Now, this case has already gone to conference multiple times with other 2A challenges like the California dunking case, which deals with magazine bans out of California, and also a ton of other 2A cases as well. The dunking case is a case that was prior granted, vacated, and remanded by the Supreme Court, after the Bruen decision. But like a lot of the other 2A cases, even after the Bruen decision, the lower courts did not want to properly apply the Second Amendment analysis. So now this case is back in front of the Supreme Court. Now, this Monday after the conference in these two cases, we once again got news that these challenges were not denied review and that they will likely be once again heading to Supreme Court conference, that they're going to be relisted. Now, right now, the next official conference date for the Supreme Court is in mid-February. So at the very least, these cases may sit on the shelf for 1 or 2 additional weeks until we get a new conference date for these challenges. Now, you may wonder, why is the Supreme Court relisting a case so important for the outcome of what could happen? Well, that is because all Supreme Court analytics and tracking on prior cases show that these challenges have a higher odds of being granted review by the Supreme Court if they're relisted only one time. In fact, according to the data for the court's 2016 to 2020 terms, between 31% and 43% of petitions that were relisted at least once were eventually granted review. And between 66% and 75% of all cases granted cert by the Supreme Court were relisted at least one time. So the fundamental truth is that a case relisted just once has a far better chance of being granted review by the Supreme Court. But also, all the data shows that multiple relists, like what is currently happening in this case and the Duncan case as well, and also what happened in the Snow rifle ban case, could be typically bad. What that means is that the data shows that a case becomes less likely to be granted review if it's relisted, 3, 4, 5 times, and as it continues to grow in relist numbers. Multiple relists often indicates that the case is going to be denied review by the Supreme Court, and that maybe you would get a dissenting opinion by one of the justices, and that's maybe why it's on hold, because a dissent is being written. So there is still a chance that these cases being relisted is not a bad thing yet. However, now that we're seeing these cases kind of get relisted more and more times as it continues to grow in number, that becomes concerning, and it's something we need to keep an eye on. And it potentially could signal a denial in these cases, and then potentially a dissent being written, like what happened in the Snope case. That was, there was a dissent written by Thomas where he was saying that they should have taken up a rifle ban case. And then you had a statement from Kavanaugh saying, well, we're going to do that in a term or two. To this point, the Supreme Court has avoided rifle and magazine bans like the plague. However, we will know soon whether Kavanaugh's promise that they will take up this issue in a term or two was actually true, or if it was essentially just another empty promise made by the Supreme Court. And we'll find out if they will continue to avoid this issue and allow the lower courts to just essentially run amok and just defy Bruen and uphold these type of rifle restrictions. So all eyes will once again be on the Supreme Court after their next conference. In these cases, like I said, that's probably going to happen in mid-February, because that is the next official conference date on the Supreme Court's calendar. They could take it up sooner, but as of right now, we don't have an official date for these relists. There is also a possibility that the Supreme Court is pushing these out because they're waiting for other rifle and magazine bans that are pending in front of them or pending in lower courts to essentially link up in conference with these two pending cases, and then they want to consider them all together and maybe do something with all those cases all at once. So that is another potential that could be happening, but as of right now, we don't know that officially. So that is what's happening right now with these critical rifle and magazine ban challenges, which are once again being pushed out for a new conference. As we get more information, as it develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm, and it just tells the algorithm that you appreciate this type of 2A content and should share it to more people. But as always, thank you so much for all of your support, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.